I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everyone doing? Happy Friday. It's Friday, end of the week. We made it. I've got a great collection of geniuses for you guys today. All over the board geniuses. I've got some Judge Clark. Judge Clark's got a new haircut. He finally cut off that hair. I don't know what Judge Van's going to talk about now that Judge Clark got a haircut. Just wait till you see it. He still looks good. Very sharp. And I've got some even more genius. I don't know. Bigger geniuses in DiSanto. And then finish with, I think, Judge Meyer. Yeah, okay. But before I get into it, you already know what to do. Like and subscribe. Do your jump kick backflips. My link tree, as always, in the description if you'd like to donate. Let's go.
What up, sir? And this is Damian Chong, Chhoeung, case number 23-2720. There's also 23-2694, although I believe those were consolidated by the state. And Judge, the state filed a motion to revoke bonds, so we're here on their motion this morning.
All right, state may proceed.
Yes, Your Honor. We want to present the court with some photos that we got off social media that was brought to our attention by our victim. I've got. One of the conditions of this man's bond is that he's not supposed to consume alcohol while he's out on bond. This photo, or both those photos, one shows him consuming alcohol. The other one shows the posting date of 9/27. The victim, who was in rehab actually because of the actions of this defendant, at least allegedly, called us frustrated over the fact that he's posting pictures of himself consuming alcohol when clearly it's a bond condition where he's not supposed to.
I guess the question is, have you got any witnesses you're going to call?
No, sir, I do not have any witnesses. And in order to get the stuff from TikTok, I mean, it's months for them to get our stuff to us.
I've reviewed Mr. Saline's response, and basically his issue is he don't know what he was drinking.
Well, it's the bottle itself.
Yeah, the bottle itself.
It's a tequila bottle.
I understand that, but I mean, I'm gonna have to make the assumption that it was after he was arrested.
Yes, sir.
Make the assumption that it was alcohol.
Yes, sir. And clearly, I'm under the understanding that has to be an assumption that the court has to make. The big thing here is we would like an admonishment at a minimum, just to not be doing this stuff because it kind of rubs his liberty in the face of the victim who doesn't have liberty anymore because of her injuries due to his actions.
I don't guess there's any way I can request you do a UA at this time, is there? I don't have anybody here.
I can reach out, Judge, and say.
All right.
And Your Honor, he does have, I think, some paperwork showing he's been going to his random UAs, but sure, he can take a UA.
He's on a conditional release also. Is that correct?
Yes, he calls.
Bond and a
weekly.
conditional release.
Yes, Your Honor, pretrial release. Yep.
Judge, I'm gonna reach out to Miss Ann and see if Miss Bird.
Nah, that's okay. I mean, if he's already on release and he's subject to random UAs at this time.
Yes, Your Honor.
Based on that, I mean, if there had been evidence other than a picture on social media that you were consuming alcohol, your bond would be revoked today and you'd be held without bond until the case was disposed of one way or the other. You are not to possess or consume. So it didn't matter if you're drinking alcohol, just having in your possession. If it's in your apartment, in your house, in your car, in your hand, that's enough to revoke your bond, hold without bond. You understand? All right. And I understand the state's position. I understand the defendant's position. Is this something that happened out on the beach?
Yes, sir.
Okay.
Yes,
I
sir.
understand the state's position and I understand the victim's position. I just don't feel at this time that, even with the low burden that I have, that the state would have, I don't know that he met that today.
Yes, Your Honor.
But you have been admonished. And Judge Restrepo, I don't believe would hesitate one bit to violate your release. Do we have another court date for him already? All right, when y'all want to set him for?
Judge, I know there will be a number of depositions. Mr. Russ Ramey represents a co-defendant, so probably a couple months, but
Yes, sir, that sounds about right.
February,
that's fine, Your Honor. That's true.
Madam Clerk, February
13th at 9 a.m. Judge.
February 13th at 9 a.m.
Yes, Your Honor. Thank you.
All right, so you need to step over and sign a notice.
And Judge, the other one I have this morning,
All right. Yeah. You're not supposed to be drinking. You're not supposed to possess alcohol. Why are you taking pictures and posting them on, what did he say, TikTok? Come on, man. Come on. Genius number 1. All right, let's go to genius number 2. This guy's kind of hilarious.
Which individual do you have there?
We have Mr. Weaver and Mr. Cruz. They're on the same warrant.
Okay, then I will take both of those pieces. Okay. Okay, and I'm done with that. All right, we are on the record in the matter of the state of Michigan versus Michael Daniel Cruz, 232-417. And the state of Michigan versus Chance Zechariah Weaver, 232-416. And Detective Sergeant Grote, your name for the record, please.
Detective Sergeant Ken Grote.
All right, please raise your right hand. Do you solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. And you may proceed on the warrant.
On Thursday, November 16, 2023, approximately 1:53 a.m., Officer Grote was on patrol in the area of St. John's and 2nd Street in the city of Wyandotte. Officer Grote observed the listed vehicle to be driving, it was a Honda, driving faster than the posted 25-hour speed limit westbound on St. John's. As the vehicle drove, it turned off its headlights and continued westbound and turned into the driveway of 414 St. John's. That is a known drug house in the city of Wyandotte. Officer Grote saw the vehicle did not have a license plate attached to the vehicle, and for the above reasons, he made a traffic stop on the car. As Officer Grote made the traffic stop, 2 females attempted to exit the vehicle and walk away, but were ordered to stay in the car. The driver, later identified as Mr. Cruz, attempted to exit the seat, and the front seat passenger, later identified as Mr. Weaver, attempted to exit the front passenger seat. Officer Grote ordered all the occupants to stay in the vehicle and requested other units. While speaking with the occupants of the vehicle, they all gave different reasons for being at that location. Officer Grote asked Mr. Weaver to exit the vehicle and asked for consent to search his person, which consent was granted. While searching Mr. Weaver, Officer Grote located a rolled up dollar bill filled with a white residue that was later field tested positive to be cocaine inside his right jacket pocket. In Weaver's left jacket pocket, Officer Grote located a piece of cellophane baggie with white residue inside. While searching between Mr. Weaver's legs and buttocks, Officer Grote felt a round, soft object that made a crunchy noise when it was touched and appeared to be a cellophane bag. Mr. Weaver was handcuffed and removed the object from his underwear. That object was a tied cellophane baggie containing 29 individual baggies of crack cocaine and 1 loose annex bar. Officer Sloan arrived to move the driver Cruz to exit the vehicle, and he stated he did not possess a valid driver's license. Lien checker Mr. Cruz showed his driver's license to be suspended. Mr. Cruz asked the officers to take the keys to his personal safe off the key ring. Lien check of the vehicle VIN number showed that the vehicle will be reported stolen out of Knoxville, Tennessee, which was confirmed by dispatch. Mr. Detective Geiger and I spoke to Mr. Cruz under Miranda, and he stated he got the car from a neighborhood friend named Tay. He admitted that he knows Tay deals in stolen vehicles, but there's a 50-50 chance the car was stolen. We also spoke to Mr. Weaver under Miranda, and he stated the narcotics belonged to him and not Mr. Cruz.
Thank you. Upon examination of the complaining witness, I find the offenses charged were committed and that there's probable cause to believe the defendants committed the offenses. And counsel, good morning. Your appearance for the record, please.
Good morning, Judge. Attorney Corey Westmoreland, appearing on behalf of Mr. Cruz.
And Mr. Cruz?
Yes.
Mr. Cruz?
Yes.
Your name for the record, please.
Michael Daniel Cruz.
All right. And counsel, as to the arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading, and my client stands mute.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And Mr. Lubianski, if you want to grab somebody else and pull them in right now, since I'm doing this, you can certainly do that. And the court and Mr. Cruz, you do have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Yes.
And you also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, ma'am.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for a probable cause conference on November 22nd at 9:30 a.m. And counsel, as to bond in this matter.
Yes, Your Honor. I would like you to know that Mr. Cruz currently lives in Detroit. He does have family that resides in Wyandotte. He is employed as a truck driver. He's not currently on probation or parole. He does not have any other pending matters out of any other jurisdiction. And after speaking with him at length this morning, he did assure me that he would be appearing at all future court dates, and he has no history of absconding. I would just ask that this honorable court take all that into consideration.
So you're not on probation at
No,
all?
ma'am. No.
You're not on parole?
No.
What about your matter out of the Third Circuit Court 2018? It shows you were to serve 4 to 20 years.
I've been on parole. I've been out for 2 years.
Please let me finish. Please let me finish. For felony possession of controlled substance, a lot of your other matters on those charges were dismissed. So it shows that you were to serve 4 to 20 years. So what was it that you were sentenced to, sir?
They had a CI working on me and they hit me with delivering a manufacturer less than 50 grams of cocaine. But
Yes,
I was
sir,
on
I
a-
see that. I'm asking, sir, you pled guilty to
I
felony
did 4.5 years.
controlled sir, please just stop talking and listen to me for a moment, okay? Because you're not answering my question.
That's what
I'm aware that you have a conviction for delivery, manufacturing of a felony controlled substance. And I'm also aware that it says your sentence was 4 to 20 years in state prison. So my question to you is, did you serve time? How much time did you serve?
that's what I was saying. I did 4 years and I did a year of parole. I've been off parole for 2 years now.
You served 4 years.
Yes, ma'am.
So that would put you out to April of 22, and you did 1 year of parole?
Yes, ma'am. And I got out on March 16th of 2021, I think. Because it'd be 2 years now. March 16th will be 2 years I'll be home.
Well, my math is different, but in any event, you're on parole, or you have a number of felony possession charges. And here you are again. All right, Detective Sergeant Grote, asked to bond.
Your Honor, Mr. Cruz has been cooperative with us during his stay here and the night of his arrest. Due to his lengthy criminal history and the habitual charge on it, we'll ask for 10,000, 10%.
The court will note, based on Mr. Cruz's criminal history and for the safety of the community, the court is going to order a $15,000, 10% bond. In the event you post bonds, you're not to be released without GPS tether. You're not to possess or consume any alcohol or drugs that are not prescribed. And I've signed the order for court appointed attorney for felony purposes as well.
Thank you, Ron.
I'm not paying that, no.
Oh, I didn't realize I put a stop in there. Oh, I hope I did it right. The next guy is the co-defendant, and he came right after. And yeah, I did have it in 2 clips. I didn't realize I put a stop. All right, well, yeah, let's watch the next guy.
Mr. Cruz, please don't interrupt the record for the next matter, please, whether you're unhappy or not. This is the matter, this is Chance Weaver, and counsel, your appearance, please.
Attorney Corey Westmoreland appearing on behalf of Mr. Weaver.
Thank you. And Mr. Weaver, your name, please.
Chance Zachariah Weaver.
All right. And counsel, as to the arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading, and my client stands mute.
The court will waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Yes.
You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to you have the right to remain silent. Anything you say orally or in writing may be used against you in writing. Do you understand all those rights, sir?
Yes, ma'am.
The court's going to enter a plea of not guilty, and we have scheduled this matter for probable cause conference on November 22nd at 9:30 a.m. And counsel as to bond.
Yes, Your Honor. Mr. Weaver currently is residing in Detroit. He is gainfully employed full-time at Mission Point Nursing Home. He is a certified nursing assistant. He's not currently on probation or parole. He has no other pending matters out of any other court. And after speaking with him at length this morning, he did assure me that he would be appearing at all future court dates, and he has no history of absconding. I would just respectfully request that all that be taken into account when assessing a bond on behalf of Mr. Weaver.
All right, and so Mr. Weaver.
Yes, ma'am.
Who do you live with?
Myself.
Have you ever failed to appear in court for any reason, sir?
No, ma'am.
You're not currently on probation or parole?
No, ma'am.
And if you were to test today, sir, what's in your system?
Weed, liquor, and the substance they found.
I can't understand the last part. What's that?
I said weed, liquor, and the substance they found.
Well, can you be more specific for the record, please? The record doesn't know what was found.
Crack is what they listed as, I think.
It's cocaine.
Cocaine. Cocaine.
So that
Crack
would
is
be
what
detected in your system also?
Yes.
All right, Detective Sergeant Grody Esteban.
Your Honor, the same as Mr. Cruz, Mr. Weaver was cooperative with the officers the night in question. He's been cooperative while he's in here, but the seriousness of the crime and no ties to the city of Wyandotte, we'll ask for 10,000, 10% for Mr. Weaver also.
I'm sorry, you said 10,000, 10%? Is that what you said?
Yes, ma'am.
The court will note that Mr. Weaver does have a criminal history, albeit lengthy. The court will also note that this appears to be Mr. Reaper's first charge of this kind. The court will note for the safety of the public, as well as to ensure Mr. Reaper's presence due to his lack of ties to the community. The court will order that 10% bond. In the event you post bond, sir, you're not to possess or consume the alcohol or drugs unless prescribed.
Yeah.
And the court has signed the petition for court-appointed attorney. Thank you. All
Thank you, Judge.
right, thank you. All right, off the record.
All right. Again, two geniuses. Good job. That big guy, man, they found that bag of, well, whatever it was, whatever drug he had in his underwear. I do not. What's the word I'm looking for? I don't know. Can you imagine the police officer that had to go searching for that? No. All sweaty and gross. Just imagine it. Let that kick around your brain a little bit. All right, last clip. I'm gonna let it run. Not gonna pause it at the end. I am gonna do a live tonight, just so you're aware. Not sure exactly what time, but I will do a live tonight. But if you haven't done it already, please like and subscribe, do your jump kick backflips, and as always, link trees in the description. All right, till next time, bye.
Did you get a chance to speak with Ms. Thompson there?
Your Honor, Ms. Capone spoke with Ms. Thompson. At this time, we are not stipulating to probable cause, but we would ask for the state to attempt to establish it.
Mr. Robbins, could you raise your right hand? You swear and affirm the information you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Go ahead.
One of the victims is her ex-husband, who allowed her to move back into her home, into his home. After 2 days, the ex-husband realized that she'd been stealing from him, and he obtained a protection order against her. The defendant then went and got herself a protection order that specified that she was able to live in the house, which caused the ex-husband to be removed from the house. Defendant then used Facebook Marketplace to sell items in the house. This was reported by the mother of the ex-husband. Then from a previous call, a civil call, Officer Leishman was able to learn that the defendant had sold a Harley Davidson to another person and provided a bill of sale showing that the motorcycle was hers. The motorcycle actually belonged to the ex-husband. In another previous call, it was reported that a black cargo trailer that was previously on the ex-husband's property was now on another property. The owners of the trailer had loaned it to the ex-husband. One of those owners made contact with the resident at the location. Officer Leachman spoke with the resident, who said that he had purchased the trailer from the defendant on Facebook Marketplace and was provided a bill of sale saying that the trailer was hers. During this investigation, Deputy Leachman saw messages that were sent to another person from the defendant. In the message, the defendant stated that she knew the property belonged to her ex-husband, but did not care. This party told Deputy Leachman that he received the message after the defendant had sold him a Chevy 350 LS motor for $750, and that he had also put a down payment on a Camaro for $150. He said that he knew that the Camaro belonged to the ex-husband and that he put the down payment on in the hopes that the defendant wouldn't sell it to anyone else.
Okay, so how many counts? She's here on 1, 2, 3, 4, 5 counts.
5 counts, and so therefore the taking the stuff and selling it, and then selling something that wasn't hers and taking the money from those victims.
May I speak, Your Honor?
What's that?
May I speak?
Not just yet, ma'am. Not just yet. Did you speak with her?
Ms. Capone spoke with her, but I would like to be heard on probable cause.
Okay. Go ahead.
Your Honor, so I believe based on the state's recitation that the 5 counts is 2 counts for the motorcycle, and maybe 2 counts for the cargo trailer, because those have a different alleged owner, and 1 count for the Camaro and Chevy 350 LS motor. With regards to both the motorcycle and the cargo trailer, the reports have conclusory statements as to who the owner is, but does not provide any information about how the officer came to that information. And even in the light most favorable to the prosecution, I don't believe that that is enough. Conclusory statements do not support probable cause. There are the messages that were allegedly sent to Mr. Durand stating that she knew the property belonged to the ex-husband, but it does not specify which property. And so that could apply only to the property, the one count, the motor and the Camaro.
Can I say one thing about
property?
So, there's a couple things here, ma'am. First of all, now's not the time to try the case. You know, there'll be a time for that. And, if you want to speak with, I'll give you a chance to go into a breakout room and speak with Ms. Anderson here if you wish to. Do you want to do that?
Yes, please.
All right. You can go in there.
Your Honor, I do not have the Zoom information for this.
We can send it to you.
Okay, thank you.
I just needed to make a quick statement about the property. None of it is actually in my.
No, I don't want you to, ma'am. I do not want you to do that right now.
And also, it's just not my ex-husband.
Yes, Anderson.